Intellectual property. What is it really? Well, there's intellectual property is all of that intangible stuff. Some of it's in your head and some of it's electronic, and a lot of it might be all over your website, but it's also your systems and procedures. So it's a whole range of things. Trademarks, patents, copyright, trade secrets, anything covered by your NDA, your confidential information, the ways in which you do things that are unique to you. All of these sorts of things cover your intellectual property. And if you don't keep track of it, you actually don't know what you've got. We often recommend people to create an intellectual property register. And what we mean by that is not keeping a list of every single thing that you have. For example, every image on your website. No, it's more about, we have a collection of images on our website. That's one group of intellectual property. We have blogs on our website. That's another group of intellectual property. We might have some sort of calculator on the website. That's another piece of intellectual property because there's software behind it. All of these sorts of things. And then you might have standard operating procedures within your business policies. All of those sorts of things will be your intellectual property. There's different ways to protect different types of intellectual property. So for example, your confidential information and your trade secrets, you'll protect contractually. So you'll get an NDA, which is a non-disclosure agreement, or a confidentiality deed, sorry. Those sorts of things are what protect unregistered and unlegislated forms of intellectual property. Trademarks are obviously covered by legislation. You can have trademarks that are unregistered, but the safest way, obviously, is to get your trademarks registered. We've got people who come to us and say, can you register this trademark for me? Well, there are rules around what can be registered and what can't be registered. So for example, generic words and words that just use location to try and differentiate. For example, garage North Lakes. You're never going to get that trademarked. Best mechanic North Lakes. You're not going to get that trademarked because it's purely descriptive and then location based. Locations are not considered distinctive. You've got to identify the distinctiveness of your trademark in order to have the best chance of getting it registered. We can help you with that. What we do is we'll review what people want to get registered, how they use it in the business, and then provide recommendations around whether to look for registration of a word mark or a logo mark or a combination of the two. There are other types of things that you can get trademark registration for: sites, colours, sounds, smells, those sorts of things. They're more unusual trademarks, but there's a lot of opportunity out there. If you're doing any sort of business with Amazon, having a trademark gives you a level of protection in your Amazon store. So these are the sorts of things that you look for trademarks. So trademarks are more around logos and short words like brand names, that kind of thing. Copyright is bigger information. So a blog article, it attracts copyright upon creation. You don't need to register copyright. In the United States, if you're selling digital content, for example, you create an ebook or you create an app or you have a video that you've created and you want to protect that under copyright law in the US, what you would need to do there is register it on the American Copyright Register. It's the only place in the world that has a copyright register, and what it requires is people to register there before they can enforce digital content, the protection of digital copyright content. Different everywhere else. In Australia, your copyright content is just protected upon creation. Now, protected does mean you need to put in a bit of investment to protect your interest. People come to us and say, can you write them a letter and stop them using it? Well, we can write them a letter, and with a lot of people, they don't realise they've done something wrong and they just go, oh, I'm so sorry, and they stop doing what they were doing. Other people don't. Oh, I'm not doing anything wrong, and actually I'm helping you by promoting your whatever it is. Those people, if you want to take further action, you still have to invest some money to protect your interests, which may mean taking court action, or it may mean doing other things to look at protecting your interests. So even though protection is automatic, you still have to enforce it. So you still have to invest in enforcing it. The same goes with trademarks. If someone's infringing your trademark and you know about it and you let that continue, you may lose the opportunity to protect it against that person. If you do take action and then you don't follow through to, for example, court proceedings to make sure they stop infringing your trademark, again, you may lose the opportunity for protection of your mark in respect of that person, and they might be able to set up in competition. So there's different aspects and different obligations, but all of them may require an investment after the fact to continue your protection. Don't just assume that because you have the legal right, people are going to stop infringing those rights because you want them to. You may need to take action. Another area that we get a lot of inquiries and questions about is these automated copyright infringement for images letters, particularly from overseas. These are all now electronically automated. So Google reverse image search, for example, tineye.com as another example. There's software out there that lets you search the internet for images that are the same or substantially similar to your image. So for example, if you take a photo in the park, or you take a photo of friends or family members and you post it somewhere on the internet, social media, it becomes available broadly. Somebody might like that image and they might copy it and use it elsewhere. If you do a reverse image search, you'll find that. So there are artists and professional photographers who have started using those services to find where their copyright images are being used without permission or without payment. And then they pay another firm to issue notices to seek payment for the use of their images. Now, if you get a letter, if you're based here in Australia, and you get a letter from an overseas company saying you're infringing trademark, or sorry, you're infringing copyright, and you need to pay $3,000+ because there's a threshold in US copyright law of about $3,500 that you can make a claim for without having to demonstrate losses. You get one of these letters of demand in the mail. If it's from an overseas company, you can probably just ignore it. If it's from an Australian-based law firm, don't ignore it. Definitely get advice. If it's from just an individual who is not legally represented and they are based in the same country as you, pay attention, don't panic. Be friendly in your response. And this is, we suggest this to people who are concerned about their rights being infringed. Probably the first and best way to approach it is a friendly communication with the other party to say, hey, look, you may not be aware. These are my rights and my entitlements and you're infringing them, and could you please stop? 90% of the time, maybe 80% of the time, 80-20 rule, people will stop. They won't do anything further. They don't realise they've done something wrong. If you go straight in with a legal letter, first opportunity you get, that can sometimes make things 10 times worse than they need to be. So self-help can work, just don't drag it out for a long period of time. But I do recommend you use that opportunity to start with. Be friendly, be reminding, let people know, hey, you might be infringing my trademark. I'd really appreciate it if you stop doing this. And often you'll get success in those circumstances. If you don't, then by all means, come and have a chat with us and we'll see how we can help you progress that further in protecting your interests. So I know I've sort of hopped around a little bit back and forward, but you have a lot of intellectual property in your business. Protecting that adds value to your business. Protect it in ways like non-disclosure agreements and confidentiality agreements where required. Understand what you've got that is copyright material and how that's protected, and do random searches out there to make sure it's not being infringed. With trademarks, keep an eye on the market, know what other people are doing, and also be very aware if foreign companies with similar or the same brand are coming into Australia and they might be wanting to use that mark here, but it's already yours, even if it's unregistered. At that point, you might want to get it registered as a preemptive protection of your mark before they come into the market. Lots of things to consider. Intellectual property is not just one thing, it's a lot of things. There are different ways to protect it. If you've got an intellectual property register where you identify the different types you've got, then you'll know what protections you have put in place to secure your business and to secure the value of your business in that intellectual property. That's part of what we use a register for. If you've got any questions, by all means, give us a call.